rise for pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Chairman Whitehall.
Here.
Steve O'Donnell. Here. Robert Howard.
Here.
Steve Bowers. Rachel Manella.
Here.
Brian Stagliari.
Here.
Denise Winfrey.
Here.
Okay, we have a quorum. We have minutes from July 8th. Any additions or corrections? We have a motion to approve.
So moved.
Second.
Motion, second. All in favor, say aye.
Aye.
Any opposed? Motion carries. First item, case 6220 MV. Who's going to take that? Okay.
Thank
Is
you,
it
Chairman.
Natalie?
Yes.
Okay. You want to give us an update on it?
For 6220? Yes. Okay. The subject property, the zoning case 6220-MSB, is located in Joliet Township. The applicant is requesting a map amendment from I-2 to A1, a special use permit for landscaping and lawn maintenance in an A1 zoning district, and a variance for lot frontage from 300 feet to 10 feet. The purpose of this request is to operate a landscaping business while having the ability to actively farm and stable horses on the property. The subject property is a flag lot located north of Route 6 and west of South Barrel Road. It is 10 acres in size and shares a 10-foot gravel entrance to Route 6 with abutting properties to the west and east. A recorded easement for access to the property is established. The subject property is zoned I-2. North, east, and west of the subject property is zoned A1. I-2 and incorporated property exists south of the subject parcel. The general area is dominated by A1 zoning. Zoning case 6220-MSB has been continued for several months. The case was initially assigned a public hearing on April 8, 2015. Staff conducted a site visit on March 16, 2015. The inspection determined that the property was in violation of the Illinois Environmental Protection Act, the Will County Building Ordinance, and the Will County Water Resource Ordinance. The case was continued for 2 months to allow the applicant time to correct the violations on the property. Subsequent to the generation of the staff report for 6220-MSB for the May 5th, 2015 PZC meeting, the Resource Recovery and Energy Division, RRE, conducted a site visit to inspect the IEPA violations. RRE found no violations on the property at that time of the inspection. The applicant had mitigated all violations on the property. Staff's recommendation at the May 5th, 2015 hearing was to deny the special use permit. The applicant requested to continue the case until all new information, including the RRE report, could be reviewed. The case was continued to June, July, and August public hearings. For the August 4th, 2015 public hearing, staff has generated a new staff report, which was provided to you, with more recent information provided by the RRE division and the applicant, including the report from the Resource Recovery and Energy Division, the recorded easement for the subject property, and proof of correspondence with IDOT. Staff and the Planning and Zoning Commission have recommended approval of the map amendment special use permit with conditions and variance. That concludes staff's analysis.
Thank you. Any questions by committee?
Excuse me, thank you, Tom. Yeah, some residents from the area are concerned about what else will be allowed on the property. The only thing that will be allowed is the farming and the landscaping, is that correct?
The special use permit is for the landscaping and lawn maintenance business. A1, as of right, you can have farming if it is rezoned to A1. There are other uses within A1 that would be allowed, such as a residence. But once it's rezoned, there are several uses that are permitted as of right, and then the special use would allow for this landscaping business.
And their concern specifically is rodeos. Did that fall into the provision?
In the 2012 zoning ordinance, there are provisions that dealt with entertainment and spectator sports. And I'm not speaking directly to the rodeos, but just generally, which that would include rodeos, but it's all types of entertainment and spectator sports. And there are quantitative thresholds that allow certain events to happen as permitted uses whether indoor or outdoor, and there are some quantitative thresholds then that would stipulate that it requires a special use permit for some indoor and some outdoor events. And basically, it depends upon how many people are there and a few other factors, but that is specifically addressed within the ordinance.
I'm sorry, David. Within the A1 specifically allows some level of entertainment use?
Yes.
Mr. Howard? Yeah, so basically, there's a 40 horse stall barn on there, or it's going to be built. And then the other thing is, do they share access here? Because I know they have a 10-foot driveway, and then one of the pictures that they sent us was actually they were locked out. Is that being handled another way, or we're not involved in that portion of it? It sounds like there's a dispute going on. So.
Any issues regarding blocking that entrance would be a civil matter, because that has to do with property lines. However, they do share, there's a common entrance between 3 properties to Route 6. It's a gravel driveway, it's about 10 feet in width, and there's a recorded easement for that access drive, stating that it is shared.
Is that the one that's currently locked, or that's a different one?
The one to Route 6 is not locked. Going back towards the property, I believe it's locked. Once again, it's a civil matter.
And there is no access here on the Farrell Road side, right?
Are there any objectors to this change? Would you like to come? You're not objecting?
I'm just comment. I want to make a comment.
You the petitioner? Do you want to come down and make a comment? State your name, please.
Louis Guzman. Everyone has 10 feet of entrance. Once I'm zoned A1, I'm allowed, I have my own driveway to come in from Route 6 into my property. Right now there is a shared driveway that everybody uses. I have 10 feet to come off of Route 6 all the way to the back of my property. And then after there's 10 feet, then there's 10 feet which belong to me, and then there's 15 feet which belong to the neighbor that's past me. I have a little highlighted thing here with my plat of survey, and it shows that everybody has entrance to their property. Nobody's locked in. When I first got to the property, it was very hard to get back there. I put all my men to work, and we put our own driveway in. And in order for my neighbor to get in, she has to clean her driveway, but she hasn't. I offered when we were cleaning, you can just pay my men by the hour, clean it, but she decided not to. So, that's why. And I put a gate on both sides, so she's also able to cross to her property. So right now, for her to get to her property, she has to cross through my property, and I allow her to do it because she hasn't cleaned her 15 feet. So I have pictures showing what she has on her 15 feet. Wish I could share them. Highlighted is her entrance. Where the car's at is, you can see the new driveway there.
Any other questions from the petition, for the petitioner?
And here are more. Those are her 15 feet. You can see. Where the vehicle's at, that is where her driveway, that's her 15 feet to get back to her property.
That's her vehicle there then?
I'm sorry?
That's her vehicle?
Correct.
How does she get it out?
And you have to get a tow truck to pull it out. That doesn't have wheels, they're all flat. It's been sitting there for quite a while.
Yeah.
And there is a gate there now, and she has to go to it. Just about 2 weeks ago, I baled the hay on her property. We went half and half, and whenever she has to get to the property, she's allowed to go through my property. I allow it, even though she has her own entrance. And she's still welcome to go through there. I'm not trying to block anybody out of their property. And I heard 40 stalls. At the moment, it's just 10 stalls. I own 8 horses, and I plan on bringing them home. I had a mare with her baby out there loose. I was asked to take them off the property, and I did, until I'm granted the A1 zoning, so.
So the horses you're bringing home are from your property in Kankakee?
No. I rent stalls on Spencer Road. We're local here from Will County, Kankakee's too far away right now. We have that property up for sale. It's in close to St. Anne and Hopkins Park, Lemont Township. It's too far for us. Right now it's just farmed, and it is on the market right now for sale, so we will not have 40 acres. I also have 10 acres on Manhattan Road. We're personally building our residence there at this time, so.
If there's no other questions.
What was the response from the village of New Lenox?
I don't believe I have one.
I can comment on that. They had no objection.
There was no formal objection filed.
Okay, we have a motion to approve the map amendment from A2 to A1.
Second.
Motion by Howard.
Second.
Second by Morgana.
Are we not going to get to talk, or?
I asked if there were any objectors.
We did, we raised our hand.
All right, would you come down to the podium, please? State your name, please.
Lois Carberry. I live at 2229 Maple Road, which would be the property east of Mr. Guzman's. I've been there 25 years, was the original buyer of the property with the other 2 people. Do not have a problem with Mr. Guzman running the landscaping operation or a small horse barn. He's already been going in and out with equipment and stuff and has been and I don't have a problem with that. I do have a problem with the variance on the driveway. That was an original agreement between the 3 original buyers. We all had access. Mr. Guzman widened the driveway, but the driveway itself is an agricultural residential driveway that was sufficient for all 3 properties. The easements were only to keep the people from being landlocked. I talked to IDOT, they were not notified of a variance, and until they are notified, they will not act upon it. But otherwise, with the driveway the way it is, the landscaping and the small horse barn, I'm comfortable with. Ms. Perez is the other resident, and she has some concerns. Would you have a question or a one?
You want to answer some questions?
Okay.
Yeah, what's the change on the driveway? What?
They want a 10-foot variance to widen the driveway to allow bigger equipment to go down.
That's the shared driveway or the?
Yeah, the
separate
shared
driveway?
Shared driveway. No one was supposed to have an individual driveway. It was shared by the 3 properties.
Okay, but there's another driveway too, though, right? Isn't there a 10-foot?
It was put in by Mr. Guzman. There was a driveway all the way from Route 6 to his property that was in place when he bought.
So that's the one that you're objecting to, is the 10-foot driveway?
I'm objecting to the entrance to the driveway being widened to allow bigger equipment to come in.
The 10-foot, the separate one, not the shared one. The way I understand it, there's 2 separate driveways.
There is not supposed to be 2 separate driveways.
Okay, but there's another driveway that was put in, a second
Yes.
driveway. Okay, that's your objection.
My objection is the entrance. Even the driveway he put in, I'm comfortable with.
Okay.
I'm not comfortable with the entrance being widened.
Okay, so you don't want that 10-foot one widened?
No.
Thank you.
For information, The variance has already been approved by PZC. We're not voting on the variance for the driveway. It's already been approved by PZC.
Who's that?
The Planning and Zoning Commission last Tuesday, they voted to approve that. They have authority to do that.
Okay, 25 years ago, you approved the industrial change for Mr. Pearson. And that was done like 25 years ago. And when they went to IDOT, he was denied the driveway because he does not have enough frontage.
We can't control IDOT.
I know, you're going to approve all this, and IDOT will still have to approve
Right.
the 10-foot variance?
I don't know if they approve the variance. Dave, do you have a comment?
No, I was just going to clarify that the Planning and Zoning Commission has already considered and approved the variance request, and that with regard to IDOT's involvement, typically there's possibly an entrance permit that may be required, so it could be reviewed at that time as well by IDOT, separate part from the county, if there's a building permit required.
The special use permit does require written approval from IDOT, and it does require a building permit, which in and of itself requires IDOT approval. The variance has been approved, but there is a difference between lot frontage and entrance. There are entrance permits, and then the lot frontage is just how much of the property abuts the road. So he was granted the variance for lot frontage because that's basically how the parcel exists. But all the entrance permits will need to go through IDOT.
Yeah, because I did talk to him this morning, and he said because there's a shared agreement on the driveway that all three people have to approve any changes.
Okay. Do you have a comment?
I'm curious, you said you object to the widening of that entrance.
Yes.
What is the objection? Why did you want it widened?
Bigger equipment. I'm comfortable with the landscaping equipment, which is trucks and the trailers that are pulled behind. I'm worried about semis, building equipment, big tractors, that kind of equipment. Because it is residential and an agricultural driveway.
Okay.
Steve?
I'm a little confused on the shared portion. The picture that I just saw showed a part of the driveway, 15 feet of the driveway was cleared off, and he says that you're allowed to use it even though it's his, and the other 15 feet has got a bunch of weeds and junk car parked there.
Because they were flagged.
But I mean, wait a minute.
Okay, I'm sorry, go ahead.
What I wanted to know is that, am I looking at this correctly, that 15 feet he cleared off is his, and the other 15 feet that's all cluttered and has a junk car on it, is that yours? Or
That is
it
Ms.
all-
Perez's.
They're
Then
both combined.
the original is combined. Part of the driveway that comes down Route 6 is on my property and his. The part that goes to the west, part of it's on my property, part of it is on Mr. Guzman's. That was the original agreement, and there is a survey for that driveway. Yes, he does have 10 more feet. Because they were flag lots, so they didn't landlock anyone, they gave them those easements.
No,
But the
what I was
drive,
trying to get at, you got a driveway, it's 30 feet wide.
right,
15 feet belongs to him,
no, 10.
10. 10 belongs to him, 10 is 10. So he cleared his 10 off.
More than that, but yes, he cleared
Okay,
his.
so then he's allowing everybody to use his 10 feet to get in. And so if he
No,
turns around,
there's,
I just asked you a question. If he turns around and says you can't use my 10 feet no more, how do you get in your house?
it's, the driveway's already there, his 10 feet is not included in the driveway.
This is the second one that we're discussing.
He put in a second driveway, yes. And again, I don't have a problem with the usage of it. I just don't want the entrance widened to allow semis and stuff in there. This is why I think they made flag lots illegal, because later on, they're just a mess.
Mr. Wagner, I really think we need to clarify that the variance that the Planning and Zoning Commission acted upon was not a variance for a wider driveway. It was a variance to accommodate the fact that there was the unallowable frontage on the area, and this was to bring the property into conformance. It is not about, never was, is not now, about a variance to widen the driveway.
So he's supposed to stay on his 10 feet, is that right? Or is it a civil matter, whether he's off his property or goes a few feet off his property?
Either he uses his own property with the appropriate permitting from IDOT if there's new entrance associated with construction, or he uses an existing established easement for access, which becomes a civil matter.
I think we need to look at our packet, stick with the matter at hand. We have a map amendment ahead of us. We have a special use permit for landscaping company. And we could get, I sense there is issues that are outside the scope of what this government body should be involved in.
Yeah, so basically what we're going to direct is, that's an IDOT issue, let them go back to IDOT. And I think we're getting too far off into the weeds on this issue. Go to IDOT, correct?
Well, it was pointed out, for the issue that you will be asked to vote on, which is the special use permit, it includes as a condition obtaining all necessary permits from IDOT.
Okay.
That's a condition of the special use permit. Additionally, for the erection of any structure on the property, he of course will need a building permit, and it is a routine component of any building permit that any roadway authority approvals that are necessary are first obtained before the building permit is issued.
Thank you for your comment. Okay. And the other objector, you want to come down? State your name, please.
Kim Perez. I am the person who owns the property to the west of the property you're talking about. And I know you're tired of this driveway stuff, but I'm not talking about the IDOT driveway part. I'm talking about, I just want to address a comment that Mr. Guzman made on Tuesday, and he also made it today, that he's permits me to call him and he'll unlock the gate for me. There's a key lock. I just gave you pictures of it. And prior he had a combination lock that he kept changing, but he's wrong. He doesn't understand, or he's not telling the truth. But all throughout your packet, it refers to this driveway agreement, which is one shared driveway for the three of us that goes back from Route 6 north and then cuts west across Carberry's property, who just spoke, across his property, and to the beginning of my property. It is separate from the deeded land access. It is not the 15 feet he referred to that's full of trees. That was that way when we purchased it. And that's why we agreed to have a perpetual driveway agreement that's one shared place, because that 15 feet, that was the only place to make the land access, because I felt that if this was contended, I was a realtor for 12 years. I felt that if this was contended, that it would be good to have an actual, for us all to have a piece of land that went to our properties, but it was, we sort of felt it was like an easement of necessity to have not clear 600 trees off of, I don't know, 900 feet of area. So we do share one. And it is not a favor to let me through there. It is a favor that I have let him lock it for over a year. Because it's right on here on page 27, and it's referred to throughout the packet. So I don't know how he cannot understand that it exists. It happens to be on his section of owned land, but I have access that was filed and recorded with the county. Okay, so that's the end of that. Unless you have questions about it.
I should get within your home prior to him cleaning the driveway.
Well, I have a Jeep, and I don't have a home there yet. However, we're retiring next year and planning to build a very nice home there, but I don't, you know.
You use your Jeep to drive over all the weeds in the garbage.
Well, it was a hayfield at one point, and then at one point, the person who owned it was Pearson Norwell Tank, and they were spewing something, they were piping something down, and it created a cesspool on that shared driveway. So I had to go around the cesspool, and Pearson also took us to court to try to go over across our easement when he bought that property. And the judge said, well, I have an easement of necessity now around that area, which I don't need now because the cesspool, he removed it, but I didn't put that on the property. So, can I continue about the other things? Okay, because it does say that for the variance for the landscaping, I did bring some pictures showing it's not landscaping and lawn care, it's landscaping and tree service, and there's cranes and heavy machinery, something grinding a big trunk like this. So it is something that I believe, as a former realtor and as someone who has 3/4 of the credentials for being an appraiser, that from these small farmettes and rural small acreages, they are not farms with big heavy machinery and a lot of noise. There are people who want these properties, who want to be in peace and quiet. The industrial that people refer to, or the commercial businesses, they are on Route 6. They're not behind Route 6. And they're also 20 feet up. There's a cliff, I don't know, they built it up because the land slopes, so they built the back of their property up, and we don't really see it. We barely hear it. And I believe that one of the, I think number 2, says that it won't negatively affect property value for the things you're supposed to evaluate for the variance for the landscape and tree service. And I absolutely, it says, you know, will not impair the property value. I said, absolutely. I would ask you to tell me what type of proof you want. Do you want me to pay for an appraisal regarding with or without that landscaping business? You know, I'll get you whatever proof you want, because absolutely, I mean, would you, the pool of potential buyers for that type of property will be significantly diminished, and I ask you if you would want to buy a residential acreage. And I gave you the pictures. The machinery is lined up, nosing to my fence. It's all pushed right into my fence. And he also said on Tuesday that he just tore down the old fence, the old boundary fence that George Pearson had put up. Well, both George Pearson and my surveys showed that fence was in the correct place. But he didn't just tear it down and re-put it up. He put it 5 feet further to my property, so all those machines are not only nosed up against the fence, but they're actually on my property. I just wonder how, with all of this machinery, and some of it's very large, how I will, when I'm living there next year, how my access in and out driving, as well as on horseback, will be affected by all this traffic and the safety. And although this shared driveway agreement allows 10 feet going west across Carberry's land and across his land, what he gravelled, and I'm not sure why, is, and I measured it in several different places, is between 17 and 18 feet. Because the size of those trucks, 2 of them cannot pass on the 10-foot. So when they're waiting to turn into 10 feet, there's going to be a backup because they all come in and out in morning rush hour and in evening rush hour. And there's a bus stop also now right at the driveway, the Pace bus on the side of the road. Also on my property, well, I guess on his property, he had some pieces of equipment and 2 porta potties that are now on my property, on my actual land easement. Does So I don't know if he's like put them there to comply or what, but I'm hoping that they're not storing human waste there on my property. And I do have a picture of that also if you need to see it.
Let me ask you a question while she's getting the picture. You have no issue with going from I-2 to A1, correct?
Yeah.
What type of businesses to be allowed in an I-2 district right now unrestricted that they would be facing if we didn't go ahead with this then?
There's different types of animal services that are permitted, building maintenance services, building supplies and equipment, construction, sales and service, financial services, office, getting to the industrial, manufacturing, industrial services.
Look like they're underwater. What's the one to the
Both
left? To the right?
limited in general.
On the-
There's various
those little
special
viaduct.
use permits.
Oh, that's the high power range. It's the pits. The pits.
You know, after reviewing
Yeah, I do. So that's
but there also is reference to illegal horses that are there. There's like 3 horses standing out there. So apparently you can't have horses on the I-2 is the issue. That's why they're illegal. Okay, so I mean, that's probably they're want to go to A2 to actually keep the horses on there. Would be my- Do you have any objection to the horses?
Well, I have an objection if there's going to be a business, and we haven't settled in my mind that there's not going to also be a builder, you know, that he is a home builder business on there as well. And then how much acreage is left for a commercial barn? You know, if there's not enough acreage, and there is going to be this 40-stall barn, which now all of a sudden there isn't, but later there could be because that's not what he's coming to you for, then I would have an objection to say there's 6 acres left and there's going to be 40, 60 horses, you know, mares and foals, as you had. Then I would, but a few regular horses, that's what people buy these properties for. But they don't buy them for giant machinery coming in and out and disturbing my use and property value. And the back gate to my property, the far end of his property is still blocked by his machinery, and I can't get into my property. It's not a favor he's granting me, that's my access. I have 2 types of access.
Natalie, you have
The special use permit does have a condition that all machinery, equipment, vehicles, and materials stored on the property must meet setbacks for the A1 zoning district.
Which is how,
50 feet from the property line.
because when the property was first zoned with the I zoning, they said he had to build a berm to hide the, whatever he was doing as well.
There seems to be like so many different issues and conditions here. So if the conditions, how often would you guys go and check this out? What's the standard for that?
Yes, I mean, there'd be a compliance verification, but it's also, we operate on a complaint-based system as well. So if the adjoining property owners believe or allege that there's a non-compliance issue with the conditions, then we would follow up on any complaints submitted, investigate, and if it's deemed to be valid, then we follow through with enforcement action.
But I think it's important to point out that for most conditions, they have a period of time after the special use permit is granted to fulfill all the conditions. It's not presumed that every condition will be fulfilled immediately. In fact, they have, in some instances, up to a year to become completely compliant with all of the conditions. But at the end of that 1-year period following adoption by the county board, then we go out and schedule an inspection and make sure that all conditions that were made a part of the special use permit are in place. But picking one situation out in particular, which is really not a question of condition compliance, it's a question of, is the activity that's occurring in compliance with the use that was authorized by the special use permit? the special use permit that's before you is for a landscape business as defined by the ordinance. If, after approval, we received a complaint that there were use activities on this parcel that did not conform to what was allowed under the specific terms of the special use permit, then we would go out immediately and take enforcement action. If, for example, this has not been alleged, it's not been discussed, I'm just giving an extreme example. If all of a sudden there was evidence of a pool maintenance business on the property, or all of a sudden a cabinetry shop on the property, if somebody called, we'd go out, and if there was evidence to that effect, we'd say, your special use permit for a landscaping business did not extend to operating a cabinet shop or a pool maintenance business. And we would follow the normal course of enforcement at that point. Did that answer your question, Ms. Sobel?
Yes. I have another question though. So this is for a landscaping business. There's a picture that says landscaping and tree service. Is that basically the same? Are they two different things? What's that?
I don't know the particular specifics on this property, but I would suggest is that, with the landscaping and lawn maintenance business, that includes pruning and things of that nature with the property. So if it gets into a business such as what you see up of I-355, where you have huge, choppers and mulching going on, things of that nature, I think that would probably cross the threshold of no longer being a landscaping and lawn maintenance business.
And again,
I gave you a picture of its huge chopper.
a friend of mine has a landscaping business and he has a lot of that same equipment that he does have. But if there was something then that she felt or the other lady felt, then they would be able to call land use, put in a complaint, and you guys would go out and see what was going on.
We would investigate and follow up, and if it is deemed to be valid, then we would commence enforcement action.
There are 10 conditions of the special use permit for the landscaping and maintenance business. Going through all 10, I don't see anything that it says the vehicles have to be X amount of feet. I'm sorry.
There are 8 conditions, so you may be looking at a different staff report. I can read the conditions.
Number 6, on sheet equipment vehicles.
Number 6 says bulk material waste stored on site, create odors.
That was part of the previous staff report. There's a new staff report generated for the August 4th PCC, which is the staff report that we're basing findings on today.
Okay.
And does that speak to the question of setbacks?
Yeah.
Would you like me to read the conditions out loud? Okay. 1, written approval from IDOT for the special use must be submitted to the Land Use Department within 2 months of County Board approval. 2, proof of architect hire must be submitted to the Land Use Department within 30 days of County Board approval. 3, building permit application and architectural drawings must be submitted to the Land Use Department within 6 months of County Board approval. 4, a building permit and site development permit must be obtained within 10 months of County Board approval. 5, the special use permit shall not be transferable to subsequent owners of the subject property. 6, all machinery, equipment, vehicles, and materials stored on the property must meet setbacks for the A1 zoning district. 7, the site development permit will require Forest Preserve District of Will County approval. 8, upon 14 days of written notice to the owner of record at their last known address, Will County Land Use Department and Will County Sheriff's Department employees are hereby granted the right to entry in and upon the premises for the purpose of inspecting the premises and uses thereon for compliance with the terms and conditions of the special use permit. That's all 8.
Those are also in the Statement of Facts and Planning Zoning Commission, and they're also located in the approving ordinance that will go to the board.
I'm reading the final staff report, so
Well, there were 2 staff reports, one earlier in May, and then there was one in July or August. August. Okay. You might have an older version there. Do you have any other comments?
I did, but I forgot it.
Okay, thank you very much. Okay, we have a motion on the floor.
Second.
We have a motion already for map amendment from I to A1. We have, all in favor say aye. Aye. Any opposed? Motion carries. Need a motion for special use permit for landscaping and lawn maintenance business? Motion?
Second.
Motion and second. All in favor say aye. Aye. Any opposed? Motion carries. This will go to county board next week. Okay, next case, 6236-S.
Thank you, Chairman Michael. The subject property for zoning case 6236-S is located in Wheatland Township. The applicant is requesting a special use permit for light equipment sales and rental in an I-1 zoning district with the intent to sell used cars. The property is located south of West 111th Street and west of Route 59. There is one paved entrance along West 111th Street. The portion of this street where the property is located contains 3 lanes with a center left-hand turn lane. A multi-tenant building, cell tower, and large paved parking lot are located on the property. The proposed special use permit would be limited to Suite F. The applicant intends to park cars both indoors and outdoors. The subject property is zoned I-1. The area is a mix of residential, commercial, and industrial zoning. The city of Naperville is adjacent to the property. Future land use maps for the city of Naperville identify the subject parcel as mixed-use commercial. Staff recommends approval of the special use permit with conditions. Planning and Zoning Commission also recommended approval. That concludes staff's analysis.
Any questions by committee? We have a motion to approve.
Second.
Motion and a second.
Just to be clear, we're making the motion based on the approval with those 6 conditions, correct?
That's always included. All in favor say aye.
Aye.
Any opposed? Motion carries. The next case, 6252MB.
Thank you. Zoning case 6252-MB takes place in Homer Township. The applicant would like to request a map amendment from R2 to I1 and a variance for front setback from 30 feet to 11.80 feet. The purpose is to allow the consolidation of the property within a budding parcel within the I1 zoning district and to bring the parcel into compliance. The general location of the property is approximately a quarter mile east of I-355. The property is northwest of South Archer Avenue. The area has a mix of residential, agricultural, and commercial zoning. The subject parcel is referred to as parcel 1 of 2. The orientation of the 2 parcels is similar to a split zone property. Parcel 1 is zoned R2 and parcel 2 is zoned I1. The request for map amendment from R2 to I1 is for parcel 1 only. The subject property is a 0.49 acre parcel. After consolidation, the property will equal 1.36 acres in area. There are violations on the property. The current use of the property is industrial, however, the property is zoned R2. The primary use is the owner's paving business. Other uses include a truck repair service and an auto collector. The map amendment will not set a precedent for I1 in the area. The intent of the map amendment is to correct the zoning violation and bring the parcel into compliance. Once corrected, the applicant will consolidate to create a single I1 property. The property is within the 1.5-mile radius of the village of Homer Glen, and it is located within the Homer Glen boundary agreement. The Homer Glen Plan Commission heard the case and voted 5-0 to recommend approval to the village board. The case will proceed to the village board August 12th. Staff recommendation is approval of map amendment from R2 to I1, variance for front setback from 30 feet to 11.80 feet. This concludes staff analysis.
Any questions by committee?
Motion to approve.
Motion?
Second.
Second. Any objectors to this? All in favor say aye.
Aye.
Any opposed? Motion carries. Other business, fair market value for the school district contribution. David?
Under the school site contribution ordinance requires an annual approval by the board of the fair market value through school district. for either cash or land contribution in a residential subdivision in the county. We did reach out to all different school districts this year and requested any updated NAI appraisals, and we did not receive any revised submittals, and so they are going forward. All the school districts are going forward with their last year's valuations that were approved by the board.
Any questions, Mike Fink?
I do. Go ahead, Bob.
You know, the problem with this, these are fictitious. They're not, these numbers, they don't, they took the height of the economy, and then basically that's where they assessed the dollar value at. Okay, and basically I think this correlates back to our property taxes. You know, I think that they use this as a basis for it, and I think that they need to do these more frequently, because like the Beecher School District, $85,000 per acre, you're lucky to get $8,500 per acre on a food lot right now. You know, I mean, so I think that's something that we need to address, you know, in the future, because I mean, this is problematic. These are fictitious numbers.
Well, first, one thing to make clear is, though, is that the evaluations provided by the school districts are mutually exclusive from property tax, the levies or valuations. This is only for school site contributions and the land or cash. Now, with regard to the valuations submitted by the districts, I mean, I do concur that, you know, they're several years old, but again, it's incumbent upon the school districts to submit those valuations to us. I can't call them to update them.
It's a direct correlation, though. When they actually, when a developer comes in or whatever, this is the numbers that they're actually utilizing. And then for the county to say, oh yeah, we agree with these numbers, or we passed an ordinance for these numbers, I think that it's fictitious. I think that we actually should address this or update this whole system. Because it's, what are we doing this for? You know what I'm saying? It makes absolutely no sense. And yes, it does have a direct correlation to your property tax, because again, when that developer comes in there and said, okay, we assess it at $85,000 an acre, that's what the school district uses. You know what I'm saying? Cash and land in lieu of cash contribution. I mean, that's, I think it needs to be fixed.
Well, my recommendation today is that to move forward on this for this next calendar year, you know, with regard to residential plats and subdivisions within the county, we've had a few minor plats. It has not had that substantial of an impact, but if it's something that the committee desires to move forward on over the course of the next year, is to perhaps bring this to executive committee as an issue to address in case we need some kind of consulting services to go through not only the school site contribution, possibly the park contribution and the library contribution ordinance, and update those as well. That would involve, you would have to involve all the different taxing bodies, all the libraries, the schools, and the parks to address this. That would be my recommendation.
Yeah, we say that every year.
I agree with what Bob said. And one of the other problems is, and I don't remember the year it passed, but it's something that's more recent, within the last 2 or 3 years, where when the assessors assess your homes, they're supposed to include short sales and foreclosures in their formula. And I personally don't see how, if they're not doing that, the schools, you're going on things that were done before, because in different neighborhoods, you have 4 or 5 houses on a block that are foreclosed on, or the people left. So there's short sales, and then there's also distressed property sales. And the way they consider that is if the house, they say the house is worth $300,000, and the person has to move and can't sell his house to anybody for over a year, and then they turn around and sell it for $150,000 just to sell it because they can't sell it, they don't include that in the formula either. So according to the state law that was passed, all that should be included. So now if the school's going on a date prior to that, their numbers are real high as opposed to being real low. And so that's why they're not addressing it. Because believe me, if they thought they could get more money, they would be addressing it every year. The problem is that every year the property keeps dropping, especially in Illinois, because people want out of here instead of being here. So, you know, I don't like what I'm seeing here.
Right.
Thank you. There's no automatic multiplier that kicks in every year, year over year, like 3%, 5% automatically?
No, it's just, the ordinance requires us to have resubmittals by different school districts, and if they choose to update them or not, that's their prerogative.
Well, obviously, the reason they're not updating them is because it was more beneficial to have a higher number from back in the day.
Yeah.
I could not agree more. One thing I disagree with, though, I do believe it does ultimately increase your real estate taxes, because what's going to happen is if the site contribution is X amount of percent larger for each one of the taxing bodies, the overall price of the new home is overall higher, and then at the end, you're receiving more tax dollars. In New Lenox, we took a very hard look at this. This took months. This wasn't something that we could just whip out by the next meeting. I would say approve this, but we should have this on a workshop or a work session, because what we found that the permitting fees with automatic multipliers were up so high compared to the relative cost. Some of the contribution fees were out of control. And when we nailed it down and then gave a discount on the contribution fees, the actual amount of permits went up. So in the end, the taxing bodies were in fact receiving more money because it spurred so much growth. So I would absolutely like to take a look at that in the future.
Judy?
Yeah, I remember this coming up last year, the same kind of conversation was held, and now here we are again a year later, and we're still in the same situation. I think it's pretty poor of the school districts that they do not go out and get it. I mean, you have valuations out here back to 2003, and the most current ones that I see are in '09. Some school districts have no appraisal whatsoever. And so by us continuing to go ahead, we are actually allowing the school districts not to redo this, not to be compelled to go out and get a new valuation. So I don't know. I don't think it's right. I don't think it's fair.
I think that, we should just vote no on this and force them to go out. I mean, if we keep kicking the can, we're doing the same thing that we're complaining about the state and about Washington. We can't keep saying, yeah, just pass it along. We should say no and make them do something.
But by not passing it, how does that affect the overall permitting process?
I have to review that with the state's attorney's office with regard to how that affect the ordinance. But quite honestly, again, unincorporated Will County, we have not experienced large residential subdivisions coming through. We've had a few minor subs that have come through. So by not having something like this in effect, I don't think it would have dramatic impact. I mean, that is an option that if the committee either continues it or if the board was to deny it, we could go back up to all the different districts and say, this will not be passed until they have a current MAI appraisal on file. But we still, I agree with the committee though, is that not just this ordinance, but the other two do need to be revised. They're from the 1970s, is what we're operating on. But I also believe, and it would be my recommendation, that there be some kind of consulting services that be engaged with individuals to have the expertise to know what state law requires and all the different nuances of multipliers and appraisals and things to do this right.
Because basically it says in the ordinance that on or before July of each year, the school district is to provide us an MAI appraisal to support it. And we also require these appraisals to be reviewed and evaluations determined annually by the Will County Board at its regular July meeting. So what we're asking being to review fictitious numbers. They're not real. They're not updated. They're incorrect or whatever. And I'm going to abstain from this because I'm not even going to be. I don't want to be part of this. Vote on this. I mean, because it's not real. It's just another problem that we have that that we're not fixing. And I know it's not land use's fault or problem. I mean, I really truly understand that. You're required to bring that before us. You are. And last year when we looked at it, it was like, well, maybe it's advantageous for the school district, but it's almost like a sham then, because now it's costing people money. So I think we just, need to actually get this fixed, and I understand it's not your problem, it's the county board's problem. I think we need to bring this up in executive and actually just have address this and get this thing done, because, otherwise we're not going to fix it. So anyway, that's
Great.
Do we have the ability to approve this based on a 90-day window, allowing the schools to come forward with their new updated appraisal, and if it doesn't appraise it, we just make it 0 or cut it in half or do something from, or would we be in a better position to do the outside consulting to get a more accurate number?
I mean, as far as the outside consulting services, what I'm referencing that, I'm talking about revising all 3 ordinances that address the mechanics of how this is done, how it's all applied. And you could get into specifics on dealing with how the appraisals are done, when they're done, and things of that nature. That doesn't get to the fact that
The number. So if we did a 90-day approval on this with the demand from the districts that they have to provide us with a current updated appraisal, would that be something that would be acceptable?
Man,
That would work? And then if they don't provide us with an appraisal, what is the board prepared to do?
Put that on file.
Yeah, I'm not sure. I don't think I've ever encountered that situation doing a contingent on something happened. That's an interesting question.
I think we should just vote it down and force the schools to do something. Say no. And then after they go do it, and they supply us what they should have been doing every year anyway, they're in violation of the ordinance right now. Anyone else in violation, we give them the riot act. So why shouldn't we give the school the riot act? I mean, really, if I have something wrong with my house, I'm going to have to address it. But the school, we're going to say because it's for the kids, we're going to give them a break for every year, on and on and on. I say we vote no, make them do what they're supposed to do.
Here's a thought somewhat in line with Mr. Tuminello's comment about trying maybe one last shot here. We have sent out an annual letter to the school districts. The vast majority of them have been unresponsive. We could table the matter that's before you today. We could then discuss with the state's attorney's office sending out a letter perhaps under their letterhead. It's been my experience that a letter from the land use department does not induce shock and awe. But a letter from the state's attorney's office indicating just simply and straightforwardly that this is the provisions of the ordinance. You are required to file an appraisal. Might result in more responsiveness, but it would really shock me though, as compelling as that might be, for us to expect that we get 100% responsiveness is probably unrealistic. But I'm just pointing out that another option that you have would be to table the matter and let us look for an alternative method that might induce better compliance than we've had thus far.
I like the suggestion of the executive committee getting a consultant to revise everything and not let the school districts determine it, have our consultant determine it. That way we wouldn't have this problem every year. We have to do it ourselves. It's our ordinance.
So I have a question. So by us approving this or not approving it, what does it actually do? What, if we don't approve this, what happens? When we do approve it every year, what happens?
When it is approved annually, and we have a residential subdivision that is approved by the board, part of the process is for us, as the department, to work with the assessor's office to establish, the fair market value of an acre, and based upon the formula that's in the contribution ordinance, determine with that residential subdivision what they would be required if they contribute land to the park district, to the school, or if they contribute the cash. And so basically, and that contribution is based upon that fair market value and how much acreage. So if we say a half acre, and the valuation is 40,000, or I'm sorry, the valuation is 80,000, and they need to give a half acre of land, then the value is 40,000. So I mean, there's mechanics there that these appraisals get into that tell us how much money is required to give to the school district
For permitting.
For permitting.
See, the inherent problem with that, though, is a developer to say, here, I'm gonna give you 3 acres that are, you know, at $100,000 an acre. I'm gonna give you that in lieu of $300,000. The taxpayer loses, the student loses, the school district loses, everybody loses on that. Because it's not true, you know what I'm saying? He hands over 3 acres, and I mean, it's a joke. And I think there's an inherent danger to all this. And you know, the other thing is just put another column on there, currently not on file, so that the developer actually has to contact the county and say, well, we have no, they haven't followed the ordinance, you know, they're in violation, as Steve said, you know, whatever, you know, the state's attorney's contacted them, you know, they'll contact the school board, there's a problem here, you know.
Well, in the short term, we do not have any residential plats of subdivision coming forward. So there's an opportunity here if the board decides to continue this for 30 days. We can reach out to the school district again, to see the attorney's office to at least try to get more current valuations. But in the long term, I do believe not just this ordinance, but the other two do need to be reviewed and revised. And when I reference consulting services, I'm not talking about having us go out and do the appraisals for the school districts. I'm talking about getting consulting services to assist us with revising the ordinances themselves. And when I mentioned the executive committee, I mentioned about possibly having that, you know, assigned not just from executive to land use, and then that would go through the normal request through the budget cycle under consulting services in the land use department for next fiscal year to try to resolve, to get this done.
So is it, I guess my question is, so is it a benefit to the school district if the fair market value per acre is higher than we might expect? Reevaluation would make it lower, so they'd be contributing less? I mean, that's what my
They
question
do
is.
benefit from a higher MAI.
Right, they benefit.
Because and I'm going to dispute that, because again, let's say if they say a piece of property is worth $100,000 an acre, okay? That's what it says right here. Developer comes to there and he says, I'm going to give you 10 acres worth $1 million. Instead of $1 million, I'm going to give you 10 acres. School board says, that's great. Give us the 10 acres. 10 acres is probably worth $85,000 at the end of the day. It happened. I've watched this happen before, where developers, you know, unscrupulous developers come in there and they give you basically worthless property for this. And then you turn around and then the school district went to sell the property. It's like, well, that's worth $85,000 an acre if you're lucky. That's the problem here. So, I mean, it's a fictitious number, and it's a detriment to the local taxpayers, because they're not getting a fair shake from the developers when they come in there and provide that to the school district.
I think that's why former boards put in this mechanism where you annually updated that baseline figure so that we were playing with what you've described as a real number. The problem that we're hampered with right now is they haven't updated it. And, you know, we can send out a notice to them and tell them to do it, but if they don't do it, then places you all in a very difficult position, because we all know that Will County is pro-business, pro-development. A developer comes forward and says, you know, although Dave is quite correct, we haven't seen a subdivision proposal in quite a while, but hopefully that'll turn around. And then one comes along and will say, I'm sorry, we're not going to be able to consider your proposal, the first subdivision proposal we've had in 10 years, because of the fact that we're not playing with a real number on the school contribution, the park contribution, the other contributions. So it has potential of stymieing development, which we might otherwise want to see, until such time as we get a real number established by qualified people, submitted on a timely basis, so that you can have an accurate computation of what the appropriate land or cash donation would be.
Kurt, I got a question. When you said that if you said no, then they couldn't develop, developers couldn't develop. I was under the impression if we said no, that the school wouldn't get any money at all from the developer. Therefore, they would be incumbent upon them to do what they're supposed to do.
You have a very good point, Mr. Balish.
I got it mixed up, right?
What's your interpretation, Mr. Council?
I have no idea. I have to research this. This is This is all new territory. We don't have an answer to all these questions. They're great questions, and I don't know.
Okay.
Let's move this along.
Yes,
We've got
we
another
have
meeting
to
I've got to
move it
go to.
along, and for cooler heads to prevail, I would like to just see us approve it for 1 year. In the last 8 or 9 years, this hasn't cost one district one penny because nothing has been approved, right? So 1 year, I mean, it's not like they're going to be lined up and there's 27 subdivisions going to be coming in based on our vote today. Most likely, we may see none or one. So this is really a moot point, and I would challenge this board to put together a program that we could get together, get on the same page, get these individual taxing bodies to get the appraisals, appraised values, and then have some consequences set up if they don't.
You know, if we did what Ray said, because obviously we don't want to say no, could we say with a caveat that they have to pay a fine to the county if they don't get it in every year?
I think we have to change the language of the ordinance. That provision is not there at the present time.
Yeah, I don't think you can do that.
You'd have to put
I'm just trying to
language,
think how we can force
you'd
it
have
to
to
do
put
it.
language to that effect into the ordinance.
We'll ask the executive committee to try to move this, to get a developer or a consultant on to update our ordinances. So let's make a motion now to approve it, and then we'll make another motion to forward this to the executive committee.
I'll make a motion to approve it for 1 year.
Second.
Motion second, all in favor say aye.
Aye.
Any opposed, motion carried.
I want to be present.
Okay, motion to ask the executive committee to get a consultant to update our ordinances concerning these contribution ordinances. Motion. Second. All in favor say aye.
Aye.
Any opposed, motion carried. Okay. Any public comment? Comments by the chairman? At the executive committee Thursday, there's going to be an item on there, the inspections, preliminary inspections. It's going to be up for discussion if anybody is interested in coming to hear that. Any comments by committee members? Director, any comments? Motion to adjourn?
Second.
All in favor?
Aye.
Adjourn. Thank you.